Good morning, hello and welcome to this Euractiv debate on tech and the next mandate. We'll be talking about all things tech, but in particular artificial intelligence. We'll be looking at the views from the different stakeholders and asking what needs to happen in the coming 5 years to deliver the sort of future that the new technologies and emerging innovations hold the promise for. We'll be hearing, as I say, from different stakeholders, including an intervention during our discussion from the rapporteur, the co-rapporteur of the AI Act, Brando Benifei, that was instigated under the last European Parliament. We'll be looking ahead to the next Parliament, the next European Commission mandate as well, and asking whether there will be more or less regulation, whether this will be the enforcement period with all those different technological regulations that are currently on the table. We're also going to look at questions of disinformation and misinformation, building on the reports and the findings that have come from the European External Action Service and how that can be disruptive to our very technology. We'll be looking at matters of privacy and data protection and how it all fits together, as well as asking what will the new European AI office be doing. So we'll discuss all of that over the next hour or so. And of course, you can ask your questions to our panelists by using the chat box there on your screen. You can scan that code if you want to use your phone to do it. You can go to Slido and use the hashtag new mandate on slido.com as well. So many ways for you to put your questions to our panelists, send them in, make a comment or share your thoughts. You can also, on the social media of your choice, add to the conversation by using the hashtag EA debate. So please do that as well. We'd love to hear from you. So, as I said, we have a great lineup for you this morning. So let me introduce you to our speakers. We have joining us Brando Benifei, MEP and co-rapporteur of the AI Act from the European Parliament. Also joining us, Alexandre de Striel, who is the academic director at the think tank CER and professor at the University of Namur, College of Europe and Sciences Po Paris. So thank you very much, bringing the academic side. Marion Fernandez-Perez is head of digital policy at BEOC, the European Consumers Organization. So we'll be hearing about that from a civil society point of view. Stephen Crisp is senior policy director and data economy and sustainability lead at Digital Europe, with a lot of experience there. And last but by no means least, we have joining us from Spirit Legal, a legal expert and privacy professional. Delighted to welcome Tia Mustach. Thank you all so much for being here. I'm going to start with asking us to set the scene. So, Brando, I will begin with you. I know that the AI Act was a really big piece of legislation, a really big win, if you like, for the last European Parliament mandate. Tell us where we are now, what's being happening, and maybe give us a little bit of insight into where things are going to go, in particular with regard to this European AI office.
Yes, can you hear me?
We can indeed.
Okay. Thank you very much for the invitation. And I think it's a very timely moment to discuss these priorities because we just started our work on preparing the hearings of the European Commissioners. We are in a very special phase of the legislative cycle. We are going to scrutinize very carefully what is the prospect for the new European executive in terms of the political program. And this entails also what to do on tech. Clearly, there is in Parliament an understanding, and I think this is shared also by the Commission, if I may, I think so, that we need to be very efficient now in implementation of the many legislation we have decided about, especially if we look exactly at the tech context. This entails implementation of different regulations, especially, and some directives, but also this entails complementing this legislation with other initiatives on the investment side, on common research, on strengthening the financial market's capability to sustain these tech developments, permanent training for people on the topic. And this also has to do with the AI Act. It's part of this implementation effort. So the AI Act has started its implementation by having the AI office installed, and the Parliament is going to establish formally on the mid-October period a permanent monitoring group of the AI Act implementation that will cooperate and scrutinize the Commission and the member states in their work of implementation, because the Parliament has a say formally on some decisions that need to be taken, the delegated act, for example, where the Parliament can object, but also on the overall process. I think that the institutional cooperation will be crucial, because the AI Act is a big piece of legislation with a lot of different aspects, and it needs um, support from all the institutional actors for it to be a success. This means that we need the Commission and the uh, Commission AI office, in fact, to deliver on the acts that are needed. And now, in this moment, it's very important that there is a finalization of the guidelines regarding the prohibitions, and that is one of the first elements to kick in of the regulation in its implementation process, and also the working groups on the codes of practice for the most powerful models. This is the topic where there is more global attention, because we are the first ones to put rules for the most powerful models with this process of having these codes of practice. You remember, for those that followed the debate of the negotiations of the AI Act, that this topic of the most powerful models, the so-called models with systemic risk, as they are called in the AI Act, it was one of the big topics of discussion between Parliament and Council, together with the prohibitions and police use of AI. And so this will be an immediate terrain of discussion and of the need also to deliver in a short time, because there is a timetable to be followed. And at the same time, we need to support, and I conclude on this point, support the anticipated compliance process, the so-called AI Pact that we are promoting to support businesses and institutions to have an anticipated voluntary compliance, which is absolutely crucial. It's fundamental that we support businesses and public institutions to adapt to the AI Act rules even before they are fully mandatory. So they are ready when the law is completely in place, because although its implementation process started, it will still take time. So we will need not to lose time, because in the end, it's not a long time. In 2 years' time, everything will be in place, and there are some intermediate steps. So we will do our best so that this model, this idea of AI ecosystem with certain values behind, the idea of a human-centric development, is not only on paper, but it becomes a real engine of transformation, also of a model of competitiveness for Europe. But this means that we also need to do other things that I mentioned at the beginning that will need to be initiated by the Commission, so that we have the rules, but we also have a competitive edge with all that is needed to support an ecosystem of AI in Europe, including clarity on rules for the use of data, which is, I think, one of the most important issues today for our businesses that want to develop AI. Thank you very much.
Thank you very much indeed, Brando. As you say, it is important to hit the ground running, because as fast as this piece of legislation was from a Brussels EU legislative standpoint, in the tech world things do move a lot faster, and there are concerns and considerations to be brought to bear there, as well as you say, questions about funding and innovation and driving competitiveness for Europe as well. So we will try to unpack all of that over the next hour. Alexandre, let me turn to you and get your perception of the current status quo, so that we can get a sense of where everyone is coming from. We have, as Brando said, the AI Act, which was long debated and hard fought, but there are other pieces of legislation, of course, that intersect with that as well, aren't there?
Yeah, thank you very much, Jennifer, and good morning. Good morning, everyone. So I think indeed, and as Brando was saying, I think one of the big challenge of the next mandate, and it has been very clearly expressed in the Draghi report, is how to enforce the new digital rule, and there are many, and regain at the same time regain competitiveness by stimulating innovation in Europe. That really will be the challenge. And I mean, I don't buy this argument that regulation is killing innovation. I mean, regulation, it's really depend on how it is interpreted. Could indeed kill innovation, but could also steer innovation, and that will be really the big challenge. So it will not be an easy challenge, and this is why at CER, the think tank where I am the academic director, we have with a number of academic colleagues, produce a white paper where we come with a number of recommendations for the next parliament, for the next commission. And basically, there are a number of them, and let me mention some. First and foremost, you need to have an infrastructure with a lot of connectivity if you want this AI in the digital society to work. And we know that this is now a big debate, and the Commission had produced this white paper earlier this year and should come with a strategy next year. What we recommend is first to have, when spectrum are licensed, it's a longer duration because, compared to the rest of the world, the spectrum tends to be allocated in Europe with shorter duration of 10 to 15 years, and we think that it can be longer. So it will give more predictability also for the telecom operator to invest. We also think that the economic regulation, there is a lot of regulation, and for good reason, to stimulate competition in the telecom sector, but could be more tailored to the real problem, to the bottleneck problem. Also, we think that competition law, and that's a broader reflection, competition policy, and it's clear also in the mission letter that von der Leyen sent to the different commissioner, should have a more dynamic approach. Competition policy should integrate more innovation and efficiency argument, and not only focus on the short term of the consumer welfare, but also on the long term. And finally, and this is maybe a bit more controversial, we think that the net neutrality rule may need to be revisited. Of course, we don't call for an abolition of the net neutrality. Net neutrality is a protection of human rights and an important one, but we have to be careful that a too strict interpretation of net neutrality would impede some innovation that 5G network are allowing. So that's for the infrastructure, which is the basis of the digital economy. Then, of course, we have AI and data, as it has been mentioned, which is absolutely key. And I think, and again, that has been well understood by the next president of the Commission, the current and the next, is that we need to have a more ambitious strategy with data, because data is the infrastructure for innovation. And therefore, what has been initiated with this Commission, with more sharing of data and those common data spaces, should probably be speed up and reinforced. And also what we call for, and again, that may be controversial, is a revision of the GDPR. The GDPR, again, it's a very good law in the sense that it is protecting some human rights, but it has, and it is more and more documented now, it had some effect on a small firm and on innovation by the small firm. So we think that there is a possibility to recalibrate, if you want, the GDPR to continue to protect the human right and the right to privacy, and at the same time not to have those kind of perverse effect on the innovation on especially the smallest firm. And finally, in terms of platform economy, a lot has been done with the DSA and with the DMA. So the question now is in the implementation, as Brandon said before. And there we think that to have a good and an effective and proportionate enforcement, first, we need to have KPI and metrics. If you want to have to a certain direction, you need to have metrics. What will be the metrics of the DMA? What will be the metrics of the success of the DSA? That needs to be devised. And also, we need to have some governance mechanism. Rules are not enough. If you want to open infrastructure, which is the goal of the DMA, open infrastructure and open data, you don't need only rules. You need a governance system which set up, for instance, the interoperability that would be needed to ensure that new players can come and connect to the big tech. You need to have infrastructure which helps user, you and me, to choose among different app store, operating systems, and so on. And we think that those governance mechanisms needs to be in place. So, that's all what needs to be done, but that will require, and that's probably the most challenging task for the Commission, for the Parliament, and for the Council, new ways of working. We cannot only continue with the way we have worked today. And there again, I'd say we have some recommendation. The first is participatory enforcement and participatory compliance, because clearly the Commission, the AI Office, the European Commission, the National Competition Authority cannot know everything. So we really they need to work in partnership with the actors to be sure that the law is implemented in the right way. The second thing, and that's also very important, we need to have an evaluation of those new laws, because mistake will be made. It's inevitable. The question is how you identify those mistakes and how you correct them. And I must say that so far Europe is not always very good at doing that. And again, there is more and more studies, academic studies, showing some shortcoming of the GDPR, and that has so far not led to any correction. And then
Alexander,
Yeah.
I'm just gonna stop you there because we've too much to unpack already from that. We'll come back around to some of those points again. We'll do it. We'll have a specific round where we can talk about the privacy issues and the GDPR. But for now, I want to go and bring Marianne in because we need to hear everyone's opening remarks first before we get into the real meat of it. Marianne, what would your perception be of the current status quo? And in a nutshell, what do we need to look at for the next mandate?
Thank you very much. It's a pleasure to speak to you today. And thank you for those that are listening as well and intervening in the audience. So I would wholeheartedly disagree with the previous speaker in most points, although I have to agree that regulation steers innovation and competition, but we should not reinvent the wheel. I think when new mandates happen, there's a tendency to want to revisit things that had already been established, and find new problems and figures that are not necessarily corroborated or the methodology of which are questionable. For example, one of the sources for GDPR costs that we've seen in the drug report referred to a PowerPoint presentation from a US multi-cloud solution company. So we wonder the accuracy of some of the basis for the claims that are being made. The key for BEOC and for consumers is that we need fair, competitive, and protective digital markets. And yes, we have regulation, but we need to ensure not only that it works, but also that we fill the gaps that are there for consumers. We shouldn't assume that what is good for businesses is good for consumers. Quite far from it. For example, consumers should enjoy a digital economy without being commercially surveilled or manipulated. And yet, 97%, that means almost all of the most popular apps and websites that we all use contain at least one dark pattern. And that must stop. That cannot continue. It is not fair, and it's blatantly ignoring rules that we have. Therefore, we are very excited that the Commission President von der Leyen has tasked a commissioner designate for justice to come up with the Digital Fairness Act to remedy these and other issues such as addictive design, influencer marketing issues, protection of minors, and so on and so forth. So this is really important. There's still some gaps to protect consumers. Some businesses are really not taking our rules seriously, and this need to change. We need more competition, not less competition. So I would be very careful to ask for more consolidation in some markets. For example, on telecoms markets. In fact, talking about evidence, the DG Competition came up with a study covering the telecoms market, but also airlines, for example, and they have concluded quite opposite things to what Mr. Still has mentioned, or what the Draghi report has mentioned. We need more competition, not deregulation agenda, and certainly we should be very careful about asking to reopen net neutrality, because as was mentioned before, this is essential for the internet, for the open internet, for businesses and for consumers. And finally, it was mentioned already, this should be an enforcement commission, because indeed we have several rules in place. We don't start from a blank page in this mandate, but they need to be taken seriously. And we need a digital enforcement strategy from this commission. We're very happy that this is being paid some attention, but we need to make sure that the enforcement is deterrent. So it shouldn't be the case that a company waits for a complaint and many years after to basically respect what democratically elected institutions have decided that is good for society and the economy. And of course, if there's mistakes, we need to resolve them, but we need to move forward to ensure that consumers have protective, fair and competitive digital markets. Thank you.
Thank you very much, Marianne. Stephen, let me turn to you now. So you've heard quite a lot there from your colleagues and fellow panelists. Tell me, what's your perspective on the current ecosystem? And obviously, I know you're going to focus a bit on competitiveness.
Yes, thank you. Look, I suppose I should start with the statement that if you are lead in technology, you lead in everything. You lead in cultural and political as well. So I think Europe is at a point where it now has to choose whether it wants to be a leader or accept that it's a follower. I think, having read the Draghi report, which was a very timely report, there are many, many stats. I just want to pick on a couple and then come up with what we think might be solutions for it. European economic growth has been persistently slower than the US over the last 20 years. I think we all know that. And productivity is now, which was 95% of the US in 1995, is now 80%, less than 80%. And we can see this, a lot of that lack of productivity as coming from not leading on or integrating technologies. Only 4 of the world's top 50 tech companies are European now. And the problem is that Europe doesn't lack idea or ambition, but its innovative companies are blocked as they seek to scale in Europe. They're hindered by a combination of factors, including often inconsistent regulation, a malfunctioning single market, an unsupportive financial and skills ecosystem. And so we've talked about AI. If we look at 61% of global funding for AI startups goes to US companies, 17% to Chinese and 6% to EU companies. Private funding for quantums, 50% is US and 5% is EU. So a weak European tech sector will not only rob us or it of the growth opportunities, for example, the coming AI revolution will bring, but it will hinder innovation in a wider range of adjacent sectors, pharmaceuticals, autos and defence, where integrating frontier tech into operations will be critical for the EU to remain competitive. So I'm still quite optimistic. What will happen in the next mandate? Well, the first thing it has to do is it has to drive competitiveness and productivity. And I'd say to do this, you have to recognise that Europe has a problem. I think that's been done. Then we look at the great assets that the EU has: single market, skilled workforce, top-level educational establishments, an industrial history to draw on. We've been here before. And an increasing realisation of the challenges. And then if we're looking at what Europe must do, it's got to develop its ecosystem so that the sector can flourish. It's got to invigorate the single market to ensure market scale with one set of digital rules, create the investment climate and tools to promote growth, gain access to deep and liquid investment capital with a capital markets union, educate and train the workforce in these new skills, give easy access to non-Europeans with the right skills, and allow them to easily move for project works around Europe, and ensure that Europe has world-leading infrastructure. There are others as well. Simplify the rules and reduce the reporting obligations. The answer to Europe's problems is not simply more regulation. It cannot regulate its way to growth. Europe may be the world leader in technology regulation, but it needs to decide whether it wants to also become a leader in what it regulates. So reduce it, simplify it, make it easy to understand, create one-stop shops for regulatory questions, and end the overlaps, relate it to commercial realities, keep it to the principles of technological neutrality, ensure timely and harmonised implementation, and ensure predictable enforcement of those regulations. And as has been stated, the EU needs to implement what is there. Regulatory uncertainty is a brake on investment, and that can be regulatory uncertainty in terms of what is coming or how the rules will be enforced. So enforce them, make them clear, make them understand. And finally, please don't run to a defensive strategy. Europe won't win by putting up barriers and hoping the world will go away. Thank you.
Thank you very much, Stephen. Tia, finally, we come to your opening intervention. But also, I'd like you to maybe, if you want to draw on some of the things that you've heard from your colleagues. I know, of course, there's a lot of discussion here about the need for balance. Give me your perspective on where those lines should be drawn. Tia.
Okay.
Oh, we can hear you. We can hear you now.
Perfect. This is a difficult position to be in after so many points have been made. I will still try to bring something new into the equation. I'm usually very loud and critical of a lot of things, especially online. By no means do I, by that, want to underplay EU's achievements in passing all these laws and AI Act in particular. But I'm here today to represent the industry, and I'm going to take a slightly different approach, or I have a slightly different focus in general. So I'm going to share 5 key concerns that I hear and trying to work on, basically daily with various businesses, but also that I discuss with some of the representatives from the authorities that are actually trying to enforce some of the regulations that have been coming from the EU. Because AI shouldn't be just a regulatory headache or just another checkbox on the compliance to-do list, and neither should technology or processing data. It should be one of Europe's most valuable assets, and I know everybody says that. However, it's currently still predominantly a headache, at least for those of us who are trying to actually help build and use tech responsibly and in compliance with all the applicable regulations. So to tackle at least some of the issues, I strongly advocate focusing on the following 5 points. First, AI and digital literacy. They are not just nice to have or even just legal obligations now under the Article 4 of the AI Act. They are the foundation of ethical and trustworthy technology, whatever we actually mean when we say ethical and trustworthy technology, but they are still the foundation of doing things right. Without a basic understanding on how these systems work, we cannot possibly ensure transparency or accountability, and many parts of our society are still missing this basic digital skills level, and unless we get some guidance and help on how to achieve this, we are not achieving anything. Second, we need a competent workforce. Countries like Thailand are already investing heavily in talent. US has been a magnet for talent for decades. If Europe doesn't want to completely fall off the wagon, or as Stephen said, if Europe decides to be a leader actually in this field, we need something. So we need to develop and we need to keep talent at home. We need to create competitive opportunities for researchers, universities, but also businesses. Thirdly, let's bring it back to data economy for a second. Alexandra already did talk about it a lot. I'm going to talk about it some more. High quality data is necessary prerequisite for high quality AI systems, but also functioning technology in general. Right now, businesses are lost trying to navigate what is essentially a regulatory labyrinth. The patchwork created by the GDPR, the Data Act, the AI Act, the Data Governance Act, and the rest. DSA, DMA are probably less my concern because, I'm not advising Meta, am I? But there are also a bunch of other sectoral, state-specific regulations, and all of these only guarantee general confusion. So we need a unified framework that gives business some clarity and legal certainty while still protecting individuals. Fourth, we have to empower and support startups and SMEs. Currently, they face massive barriers, especially in markets dominated by the big players. We need policies that enable smaller companies to fill critical gaps, for instance, by doing chip production. And we also need to build neutral infrastructures that help level out the playing field. We need more than, just mentioning them in various recitals. We need to figure out how to effectively enforce the DSA and DMA to actually provide some support. And finally, enforcement. It was mentioned by several speakers. Right now, it's fragmented across the EU with planned self-certification of AI systems. It's inconsistent regarding oversight measures, and there's a lot of pressure on the national authorities. We need harmonized enforcement. And what I mean by that is clear, standardized testing, certification schemes, and oversight at the European level, to make sure that these regulations are more than just letters on paper or on screen, however you want to have it. And we need guidance on how all these various regulations interplay with each other, and how do the authorities' tasks and responsibilities, so of authorities overseeing various regulations, how do their tasks and responsibilities interplay with each other. Only by working on these areas, and at least 20 other, which I haven't, and probably we all in this webinar haven't even mentioned, or maybe even thought of, only by working on all of these can we actually fix course and get us back into the race for the lead of both development as well as regulation, because currently we are lagging behind. But that point was made for me basically by the previous speaker. So let's start doing something, I would say.
Thank you very much, Tia. I think already we can see some certain points of agreement between you all. I think there's a general consensus that Mr. Draghi's report is not wrong. It's in terms of the fact that the EU is lagging behind. The question is really how much and to what degree people agree with what to do with it. I think also another area that I hear a little bit of consensus on is that all of you want to see a safe, positive and fair online platform ecosystem. I think, however, the disagreement may come in defining what exactly is meant by fair and who should be the key considerations when we decide what we mean by fair. Alexandra, I'd like you to unpack that a little bit. When we talk about fairness, if you like, in the online platform world, we'll stay with that, so we're looking a little bit DSA, DMA rather than AI Act here. How would you define it? What would you see that as meaning in terms of what should be forefront of mind for the next Commission, for the next Parliament, for all the stakeholders that are going to be looking to the future?
Yes, thanks. Yeah, I think that would be one of the key questions, and it's in a way linked to that kind of industrial policy that we want to have, because platform economy is one of the elements of it. And one thing for me, fairness means that you have to support entrants and innovator, and you have to create new value that then you redistribute it in the fair way. And you should not, just use those law to redistribute it, to either pick winner or to help the loser of the industrial revolution, because we have, in every industrial revolution, and the digital is a big one, and to redistribute from the innovator to the loser of the industrial revolution. What we need to do, and that's what to me fairness means, is to have a level playing field where everyone, a small and a big one, from wherever they come, can innovate in Europe, support those entrants, and not just support the incumbent, which are already there and which sometimes miss and are not innovative enough. That's how I see fairness. Now, how you achieve that is by an interpretation which allow everyone to be around the table, the existing player, the big tech, for when we talk about the DMA and the DSA, and the entrants, so the small tech, the tech challenger, and you see how you can work together, for instance, in terms of interoperability. I mean, this is a very complex question. So you would need to have, I would say, weekly meetings between the tech challenger and the big tech to see how it works and how, you know, a small tech challenger can strive in Europe.
Stephen, let me bring you in on this point. Alexandre mentioned interoperability. When we're talking fairness, if we're talking fairness between different competitors, different companies, how important is interoperability there? And we'll come back around to the idea of where civil society and consumers fit into this fairness matrix.
It's a good question, isn't it? Because we have different views on this that go across. I think, I mean, fairness is, as Alexander said, fairness is a very good point in terms of you can't just back up the current incumbents. And the problem with innovation is that you know who the victims are going to be, but you don't know who the gainers are going to be. So you can see the changes happening to your regulatory world, to your industrial world, but you can't see who will benefit. And this is why you have the protests and so on, because people are worried about their current jobs. They can't, of course, predict their jobs in the future. When you're talking interoperability, can you just define what you mean by that before
I mean, obviously, interoperability can operate at a number of different levels. I mean, we're talking about things like data portability and systems that allow some of them the power to go back maybe into the hands of the consumers, the data owners, the data producers, and whether they can benefit from interoperability as a method for creating, if you like, a more competitive landscape between different providers and different services.
Yeah, sure. So look, I mean, whilst we do have to take, when we're looking at this, we do have to respect IP. We do have to respect trademarks. We do have to respect rules around those items. We cannot simply tell people that their carefully garnered commercial advantage has to be given away. That is not an option, but at the same time, the contracts and the contractual terms have to respect copyright. They have to respect IP, and they have to respect commercial imperatives as well. Or what would be the point if you're going to be forced to give it away in the first place?
Marianne, competitiveness. I mean, businesses have a right to make money. Where do we say? Consumers have a right to be treated like people, not simply as users, but where is your perspective on the fairness?
What you say is absolutely right. Consumers are not a product. We're all people. Even people are behind companies, and so innovation needs to serve people, should not harm them. And unfortunately, the reality is that many times some of the innovation harms people in many ways. What we want, for us, what fairness means is for consumers to be protected by design and by default. It also means that their choices need to be respected. Privacy needs to be respected as well. They basically need to enjoy services and products online without giving up their autonomy, their fundamental rights, consumer protection, which is not really happening at the moment. For that, we need to enforce current rules in an efficient way, which is not happening. We should not reopen successes that protect people, like the GDPR, which, by the way, are the foundation of many other laws. If we reopen some of these successes for consumers, we will be putting into question the foundation of the protection and innovation in the European Union. So we need to be very careful about how. It is important to make sure that consumers are treated fairly. The how is really to fill the gaps. We already mentioned one element to do that, which is the Digital Fairness Act. The Commission understood the importance of doing that beyond the platform ecosystem, by the way, because it's not only about platforms. And we need to enforce digitally the rules that we have. So the rules serve people, not only big players or companies that do not respect the law. So it is unfair for those businesses that respect the law, that devote time and efforts to respect the law, and have those that disregard completely our laws to keep making money without any consequences.
Well, there's a couple of things I want to take from that. I mean, you mentioned businesses that ignore laws. I think if there were no bad apples, we wouldn't need any laws at all, because everyone would operate in a way that was ethical and fair. But we do need laws for those that are less inclined to be considerate and operate in an above board way. You say the GDPR has been a success, Marianne. So let me come back to you and say, I mean, as a law, it might be great for enshrining the rights, but its enforcement has been patchy, to say the least, up to now. Is that not fair?
It's very fair to say, and BEOC has had a lot of experience on these, because we bring coordinated enforcement actions together with the members to respect and bring more fairness to people's personal data rights. In fact, for example, we have a case against Google location tracking that we launched in 2018. Where in 2024 the case has not been solved, and this is a shame, because in the meantime Google keeps profiting from what could be potentially illegal processing. Of course, we will see what will come out of this. Luckily for us, we're in the process of having cross-border GDPR enforcement regulation being negotiated, and we're entering the last mile in the negotiations with the trilogues, as we call it in Brussels. So we are hopeful that this regulation, if it gets it right, will improve this evidence gap that we have in ensuring the GDPR remains a success.
Well, Tia, let's come to this enforcement question. If enforcement requires organisations like BEOC or NOIB or these others to bring the cases, is that regulation really functioning as planned if it's not within the reach of ordinary consumers? And how do we make sure that the AI Act doesn't end up maybe falling into some of the pitfalls that we've seen with GDPR enforcement?
That's a complicated question. And with AI Act, I'm not sure whether it's going to be even worse, considering that it's a product safety regulation and there are no direct rights for the affected persons. But I mean, as we have seen by the development and by the strength of all these organizations, there obviously is something that we are missing out here, because a single consumer that is actually suffered damages and is willing to fight for them isn't strong enough to actually achieve something, or to actually achieve a meaningful difference for everyone else that suffered the same thing but is not willing to fight or drag himself through legal processes. What enforcement at a very basic daily business level boils down to is, I have accepted cookies for this local provider of this local thing that has no idea actually what is going on, even by implementing Google Analytics, and he only did it because somebody told him that it's good for marketing. And then you sue this small company and you get some damages, or you don't get damages from them, and that's it. And Google continues doing their thing. Nobody continues understanding why this was problematic in the first place, until someone actually involves these organizations, or the organizations involve themselves and actually state on a European level, guys, we have a problem here. Can we deal with this at a European level, because it's a European problem and not just from XY located in some country, in some city that maybe enforces, maybe doesn't enforce. I'm not sure. Luckily enough, I'm currently in Germany that at least enforces a lot of those small requests that don't change the big picture, but at least achieve, well, something resembling justice on a small scale. But I mean, my home country is Croatia, and I can tell you there is not a lot of GDPR enforcement there, simply because, we have burning issues. We will deal with that when we fix the other things. And until we decide to actually deal with those things on a European level and to apply for everyone, yes, we definitely have an enforcement problem. And as I said at the beginning, I'm pretty sure that the AI Act can only be worse and not better.
Well, Tia, my home country is Ireland, so we won't unpack the GDPR questions there today because that's far too big a can of worms for the time we have left. I'm going to go to some questions that we've had coming in. Alexandra, let me put this to you first. It's coming in from Serena Bresnan, asking how can the GDPR and the DSA balance compliance with the flexibility to foster AI while also ensuring that researchers in particular can handle data without excessive legal burdens and avoiding stifling innovation? Because this question of what researchers need to use in developing and contributing to the innovation ecosystem is a key one.
Yeah, absolutely. The question is great, and let me clarify. I'm not against privacy, and I'm not against the protection of that human right. I think it's a very important one. I just want to remind that the GDPR, it's a law which was based on a directive of 95, which itself was based on a convention of the Council of Europe of the 80s. So the logic of it was really the logic of the system. The substantive, I'm not talking about the enforcement, was dating back from the 80s when we didn't have AI, we didn't have this importance of data as an infrastructure. So my point is that we need to reopen it because the world has changed, not because I want to reduce the protection of the user or reduce privacy. And in particular, and I think that the question which was asked put that very, very clearly. I mean, we need more data to innovate. And so to me, the important thing is to focus now the protection, not so much on the data collection or the data exchange, but on the data use, what is done with all those data, and that's where I think the regulation and the enforcement should be. So to move from collection to use, that's really what I would call. And, because the dilemma is clearly there, how you ensure innovation, because it has been said before, the one who control technology control the destiny, to some extent. And it has been done, it has been the case since ever. I mean, since all the civilizations. So I think we have to be careful that if we lose our leadership in technology, we lose all our value with this, okay? So that's really why I really want that we update our law given the new technology and to protect the user in the same way. Net neutrality, because there was a question there. I don't know whether it will be in the possible DNA or not, but I think again, I mean, those rules date back from 20 years before all the innovation which are possible with 5G are allowed. So really, I think we need to keep the same spirit of protection, but adapt it to the new technology and allow those innovation to take place. Otherwise, we lose everything, competitiveness, our value, and everything.
Well, Stephen, I'd like to hear from your perspective what you think about the idea of revisiting or reopening the GDPR before we move on to some questions regarding the Data Act.
Well, we have the GDPR review, of course. The issue for us with all regulations, directives, acts, etc., is their implementation. Okay, regulation essentially has to be it has to be fair. It has to be dealt with in an equal and equitable way, and it has to be predictable. It's an investment break if your regulation is not predictable. So one of the things we're very keen on looking at is the 28th regime, and the possibility of putting implementation of rules that haven't yet been agreed into that, or to try and drive a unified implementation of the rules. GDPR's real problem is that it's just being implemented in different ways across essentially 27 territories. And if you are if you're one of our members, that's difficult to scale up across Europe if you're having to do these rules in different ways. And we get it with other rules as well. It's not just GDPR. So revisit it, well, going into the principles of it, probably not, but it does need review. The implementation of it does need review. And the way that we do regulation in general also needs to be looked at, because it is causing, it's just becoming too expensive. So I'll just give two examples, if I may. The one was the Commission's 2021 impact assessment of the AI Act, estimated that the compliance cost to an SME of just 50 employees placing one single AI-enabled product on the market would be over 300,000 euros. And that is a cost for an SME. It's also a proportionate cost against a big company. It's even bigger. The other one is that, and this is not scientific, so please don't quote it as a Digital Europe item, but we've been talking with our members, and a large number of our European members are now saying that they are spending more on compliance than they are on R&D. And to put that into perspective, it means that European tech companies are having to spend more on lawyers than they are on engineers. They're having to spend more on lobbyists than they are on scientists. And this is, if this is true, and if it comes out to be true, it has to be dealt with. We cannot have these very, very high level compliance costs at what essentially becomes the expense of our future research and development.
Well, I see another question coming in, I think a little bit more related to the Data Act and others than GDPR. Francisco Medeiros is saying, isn't the concept of data sharing by regulation just wishful thinking? Sharing of data will only happen in a win-win environment for both sides of the equation, data generators, data aggregators, and data users. Stephen, do you want to just give a quick response to that?
Well, I don't think that's an either or. I mean, regulation is a necessity of business. Let's be honest about what regulation is. You can't have a regulation-free world, but it has to, as the principles I've earlier said. Our concern is with the Data Act is the model contracts, for example. You need to allow commercial organisations to do the contracts between themselves. The model contracts can't be governments intervening between the contracts of two commercial operators. Is the Data Act? I mean, the issue with the Data Act is it's not been implemented. And we're looking at regulatory uncertainty for our members through lack of implementation.
Mariant, a question for you from another audience member, Yvette Templeman, wants to get the BERC perspective on whether the current legislative landscape is very challenging for SMEs and whether enough is being done to assist businesses in understanding this complex landscape and being able to implement all those interacting rules. I think I'll take as a backdrop to this that perhaps SMEs in particular want to protect their customers, want to make sure that they are compliant, but they need assistance with this. This is something that big internationals, big tech can afford to do with teams of lawyers, but it is more burdensome, isn't it, for small companies? Do you have sympathy with their position, even while the consumer remains paramount from your perspective?
I, of course, have sympathy to the fact that small companies need to respect the law. I mean, at the same time, for a consumer, it doesn't matter the size that you are. You need to ensure that you protect people, right? So if I go, let's say, to a small restaurant next to my house, even though it is small, I expect not to be poisoned. So it shouldn't be different online either. At the same time, to respond to the question more concretely, there has been efforts that have been put in place to assist small companies. There's a lot of guidance from various authorities. The European Commission has also done support about that. Even BEUC and our members, we have a program called Consumer Law Ready, where any company, in fact anybody, can just go online and try to get more familiarized with consumer law requirements. So we take it very seriously to inform consumers and to ensure that everybody, regardless of size, complies. But if I may, just as an additional point in relation to previous questions that have been made, I think the problems with SME scale-up is not so much about regulation and enforcement, because in reality, if you look at the enforcement landscape, the focus of regulators is about the big infringers, not really the smaller guys, especially if you look into how many small companies we have in Europe. one of the main problems is, in our view, is the fact that there's not enough competition in digital markets, and we need to pay attention to that, because it seems that for very small companies, the best that they can happen to them in some cases is to be acquired by bigger ones. And is that the type of innovation that we want? That is a question for us. I hope also for other panelists as well. Thank you.
Thank you. I have a question now that I want to put to everyone. We've talked a lot about this network and interlinking series of regulatory enforcement, regulatory measures that have been put in place for tech. Are there still any gaps? I mean, a lot of these regulations are about reining in the bad actors, first do no harm, which is, of course, an admirable approach. Are there gaps where regulation could in fact help? Are there support mechanisms? I know, Tia, you spoke a bit about a need for a skilled workforce. Are there any more positive measures that we see that could be put on the table during the next mandate? Tia, I'll let you start with that, but I'll come to everyone in turn.
Well, I would say definitely. There will always be gaps when you have a patchwork. It's just a matter of time before someone sees it, and a matter of even more time before someone actually addresses it. And I mean, one of them is actually guidance. I know that Marianne said that there is a lot of guidance. Sometimes the guidance is kind of, well, takes opposing views. So you have one authority saying that something is okay. You have other authorities saying something is not okay. Have one authority saying, I don't know, LLMs don't process personal data. Another authority says, yeah, they kind of do. So it's not necessarily about more guidance. It's about having a uniform standard for what is or what isn't. And I mean, whether you would define that as a legal gap or would you define that as an enforcement issue, that is a separate thing. But it is an issue and it is a gap and it's being exploited. And when it comes to actual gaps, I think actually the AI Act and the GDPR framework are somewhat complementary in, for instance, closing the whole automated decision-making circle with now the AI systems, which kind of complement each other, I would say. But of course, as I said, whenever you have so many different regulations, you will find something. You will find something that is not regulated or maybe is regulated differently in another regulation, and then you just pick and choose which option fits you more. Is something personal data, or is it rather a data in a data act, data economy type of data that I can use? Well, it depends on how big of a legal team you have and how good they are at explaining why something is or isn't personal data in that particular case, because you anonymized it at state-of-the-art levels. So basically, to come to a conclusion of this incoherent statement that I just had, I'm sure that there are gaps. There are some of them are related to enforcement, some of them are related to contradictory statements, contradictory guidance, and even contradictory regulations. And it's just a matter of time before someone finds them, and then how we deal with them, well, that's on us.
Not incoherent at all, Tia. I think a fair reflection of how interconnected and complicated and connected these issues are. And I think you're touching on a central point here, which is that most of the regulation coming down at EU level aims to streamline. The whole point of having an EU-wide regulation or guidelines is that we don't have this patchwork between different member states, and yet, of course, that comes up short in a lot of respects. Alexandra, where do you see the gaps? In particular, if you can identify gaps where systems might lift up the whole ecosystem, guaranteeing fairness and security for people and users, but also helping businesses remain competitiveness and take Europe from the position of laggard to leader in technological innovation.
Yeah, so I mean, for me, the gap is clearly not so much in terms of regulation, but it's all the other way, the other driver of innovation, you know, finance, capital market union, skills, migration, and I would add defense, because I think, you know, we know that a lot of new innovation are coming from defense. So I would say the biggest gap that we have now, and which have been identified to some extent in the Draghi report, is all those other driver of innovation than regulation. So I think that's why I think the conversation should shift, and that's why it's so difficult, because in Brussels we are used to speak about regulation because that's the main power, if you want, of the Commission and of the European institution. It is to adopt law, not to do industrial policy, not to do defense and all of that. And that's why I think we have in that difficult situation, and that's where the gap are. Now, if we talk about regulation, but again, I repeat, to me, that's not the main gap by far. I think one thing where we may see more activity is around online advertising, because to have a lot of business model or a lot of so essential services which are only financed by advertising, I think there is a question here to be asked, whether this is the right approach, because if you ask to many of the viewer or many of the European citizens, would you like that school are financed by advertising? Many people would say, no, we don't think it's the right approach. But we have services, digital services, which are as essential as school, which are financed by advertising. And I think there probably there is a question to be asked, and a gap to be think of.
Thank you very much. Stephen, your thoughts on whether there's gaps where assistance might help the competitiveness ecosystem?
Thank you. So I was violently agreeing with some of the points being made earlier. But the first thing I'd look at is that we don't have a deep or liquid enough investment market in Europe. So I think the creation of a capital market union is essential. The access for innovative companies who want to scale to money, to finance, to risk-taking finance is essential, and it's not really available in the way it should be in Europe. So that's one of the that would be a very important one. The second is maybe look at significant targeted public funding to enhance innovation, accelerate commercialization. I mean, I'm talking about taking from up to unicorn level of companies, address the specific gaps in the technology sectors. Look at maybe developing a common EU procurement thing item to ensure scale customers. The thing is that Chinese companies, and I've, as I think people have seen, I've lived a number of years in China. The thing is with Chinese companies and with American companies is they have access to very large procurement business, which will then allows them into to grow up, to become big. I think also maybe look at, quite controversial, but look at a skills passport. Maybe it's time that we actually understood that the skills issue is really important. Are we going to make ourselves an innovative leader by building huge fab factories and things? Maybe, maybe not. But what we do need is the ecosystem that allows innovators to grow, and the skills that allow them to create and to grow. So those would be my initial ones. I think we also need to look at wider aspects, but those would be the big ones.
Well, I think we're probably running short of time, but I'd love to know at a later date what you want to have on a skills passport. It sounds interesting. Marianne, let me come to you now. I know if I ask you where the gaps are, you're going to say we need a Digital Fairness Act, so we'll take that as read. But I'm wondering if there's other areas, perhaps in protection of minors or identifying where we need more support that you see as a gap currently.
Absolutely. I think the biggest gap is that we need to ensure, as I said before, that we have fair, protective and competitive markets. We are not starting from a blank page, it is fair to say, but there are significant gaps for the protection of people, and not only minors. I mean, of course, minors are very important as a mother, and that is also very important for me and for many people. And this is something that the EU needs to step up and better protect consumers to address the digital asymmetry of power and the digital vulnerability that we all have, particularly some consumers, but in fact, all of us, we're vulnerable to some business models that exploit our data, that exploit our vulnerabilities online, and that do not reflect in their business model consumer protection by design and by default. So therefore, we need to make sure that in this mandate, consumers are put again at the center. We need leadership to think that not only we need to look at what is good for business, but also what is good for people, because without demand, businesses cannot also work. So you need to put consumers at the center. Thank you.
Marianne, I'm going to ask you a follow-up question because I'm going to finish with a couple of specific questions from our audience. So we've tackled them all before we do a final round of everybody's wish list. Michael Freytag is pointing that there's been a human-centric approach to AI that is essential and is particularly essential in HR services. I'm just curious, just as a follow-up then, Marianne, are you happy with the risk-based approach to AI, and is it sufficiently, the AI Act that we have now, is it sufficiently human-centric as was promised at the very outset?
Thank you. The short answer is no, we don't think it's enough. Of course, there's a huge milestone in the sense that it's the first time that we have a comprehensive law on AI, but it fell short on protecting people. We are, of course, happy that things like social scoring are banned, but there's a lot of things left to self-regulation, other things that are not covered, like, for example, or not covered enough. For example, let me think, emotion recognition is not banned. Virtual assistants or AI-powered toys, talking about minors, will not be regulated enough as they're not considered high risk. So even though maybe it makes sense to regulate things as per their risk, we are not sure that the categorization that was done was considered right in all fronts. And talking about gaps as well, we have the AI liability directive that is pending. The agreement at the time was to wait until the AI Act was adopted to conclude it. Recently, we saw a study commissioned by the European Parliament on this, showing still the need for this, and we couldn't agree more, because we need to respond to the question like who to hold responsible if something goes wrong in the AI value chain.
Well, no doubt Berk will be in touch with the new AI office with lots of suggestions and ideas. Alexandra, I have a specific question to you from Senia Juxfeld-Karakina, wanting to know what you suggest in the new, if you like, your view of the net neutrality worlds. What would you like to see in a new DNA? I'm going to ask you to keep it brief, but if you can give us in a nutshell, what do you think the net neutrality regulation should include?
Yes, so I will be brief, but there is more detail in the SARE white paper that we published on the SARE website. But basically, I think our idea is to say, look, I mean, the way the net neutrality, at least not so much the rule, but the way they have been interpreted by the Court of Justice is extremely strict, you know. So basically, you know, it doesn't give any margin of maneuver for the telecom players to manage their network and to benefit from the new possibility of innovation that you get from 5G network. So basically, you know, it's a bit too much of a straitjacket. So what we suggest is to flexibilize a little bit the rule, protecting, of course, the right of the user, but with a bit more flexibility. That's what bit more flexibility to have this innovation. That's what we suggest, but more detail in the SARE report.
Thank you, Alexandra, and people can find that on the SARE website. So we'll do a final wrap-up. We have a new European Parliament in place. We should hopefully have a European Commission new mandate in place by, let's say, December. So let's say this is a Christmas wish list that you're going to give me. Let me start, Stephen, with you. In a minute or so, tell me what you think you would like to see for the next mandate for the tech ecosystem. That can be AI, that can be DSA, that can be on strategies with regard to funding or innovation support.
Okay, so first and foremost, implementation of the Data and AI Acts. Make them work. Those would be key items. Push towards the link between security and defence, and push towards the link between security and defence. we need to know what we mean by that. Do we mean economic security, or do we mean strategic security in a more narrow sense? Really drive for regulatory simplicity, put the acts that can't be implemented or haven't been implemented, really focus on that 28th regime as a way to deal with this. But basically get done what we have being done, as in finish it, get it implemented, get it enforced, get the regulation to be fair, and look at how we can create that ecosystem.
Marianne, your wish list for a new Parliament/Commission mandate, please.
It's a long one because we'll cover many different markets, but just to give you a high-level pitch, so consumer organizations want Europeans to live in a fair market, online and offline, where the sustainable choice is the easy and affordable one, and digitalization works for the benefit of all. And this mandate is an opportunity to bring improvements, to stop commercial surveillance, to keep working to ensure that AI and emerging or frontier technologies benefit consumers, do not harm them, and make sure that what we have right now works for people. So enforcement that is deterrent and effective for people to work to achieve the objectives of the rules that we have set in place, and fill the gaps where these are needed, including on the Digital Fairness Act, including on following on the e-privacy regulation proposal that is now in an impasse, ensuring not to or resist pressure to reopen successes for consumers in the previous mandates. So do not reopen GDPR or do not reopen the open internet regulation. We need to resist pressure to put into question key victories for people, and technology should really adapt by the law and not the other way around when it's not convenient to protect people for business. Thank you.
Thank you, Marianne. And Alexandra, your final wish list, briefly, because I know we can all go and check out the self paper.
Yeah, I mean, I think there is two elements. One is enforcement, as it has been said, and for that, I think the European Commission or the national regulator can learn a lot from how the digital platform, are functioning. So it may sound ironic, but I think the success of the digital platform is due to the fact that they are able to create an ecosystem of something. And here, I think the Commission and the regulator should create an ecosystem of compliance with all the actors incentivized to comply, and they experiment a lot. They learn and they adapt, and that's exactly what we should do as in enforcement. We learn, and if it doesn't work, we adapt. Okay, that's the first thing. The second thing is industrial policy, and I think we need to have a smart industrial policy which is supporting innovative entrants. That's exactly what we need. So in a nutshell, we need to go from a regulation commission to an innovation commission.
I think an innovation commission, that's not one I've heard yet. I've heard a lot about enforcement commission, but I think innovation is a good, positive word to take forward. Tia, your thoughts to wrap up. It's both a blessing and a curse to have the final word.
Yeah, and what better way to finish with my very early Christmas wish list? Feels great. Well, I want AI to be more than just a regulatory headache, and I want you to lead with clear guidance, and I want to see all those templates and guidelines that the AI Act promises to deliver, or to have AI Office deliver, or to have someone deliver. I want empowered startups, and I mean grants, financial support, tax holidays, and again, guidance reaching those that actually need guidance instead of just recitals stating, we support innovation and we support startups and SMEs. That doesn't cut it. I want strong talent pipelines, and yes, part of it is working and stimulating AI and digital literacy, but to stimulate meaningful understanding of the technology. But I also want talent to actually stay in Europe, because we have a lot of it and we build a lot of it, but it usually runs away. So I would like to change that. And I want enforcement that actually works. It's not carrot or stick, it's the carrot and the stick. It's about stimulating compliance because it's good for business, because consumers trust you and consumers want to actually use your product. But it's also about finding violations and finding them appropriately, and not just finding, the people who didn't know better, but actually finding those who did know better, but still decided not to do the better thing. And yeah, basically, I want the future of AI to be for all of us and not just for the tech giants. And to do this, we need everyone on board and at the table, and we need them tomorrow.
Well, thank you very much. I think message there from all of you is no time to lose, albeit we might be waiting a little bit longer before we see a full commission lineup, but we will watch this space, as they say. Thank you all very much for your input, and thank you for you at home for your questions. I see one last one saying, how do we minimize or abolish all the existing rules? I think, Eric, that's probably not one that's going to happen. That's not desired by either us or any of our panelists. But thank you for joining us. Remember, you can follow us here using the hashtag EA Debates. You can find out more about upcoming conferences, webinars on Euractiv.com or email events@Euractiv.com. Thank you very much for joining us, and have a great day.